Hi friends, today we are going to discuss legal aspects of medical practice Bolam test. Myself, Professor Suresh Badadmat, have done my MD DNB and also medical law ethics and also human rights law, PhD in law from National Law School. Currently, I'm working as a professor of psychiatry, head of telemedicine center, head of forensic psychiatry services at NIMANS, Bangalore. I do also teach in National Law School as an honorary teacher for medical law ethics program. Before I start my presentation, I would like to have a disclaimer. This presentation is basically for academic purpose only. If you would like to have any legal opinion, please do contact an advocate. This presentation is not a law themselves or not a substitute for legal profession. This presentation do not discuss any individual legislation like MTP Act, PNDT Act, TOA Act, POCSO, Mental Health Care Act, or RPWD Act, and so forth. There are many acts which I am not going to discuss. Now we will consider Bolam's test. See, this Bolam's test has been considered as one of the gold standard, or what we call it as a landmark case or a celebrity case in medical negligence. Before these cases before this case came, there were hardly few cases on medical malpractice. So what do this Bolam's test talk about? See, again, this is a Bolam is a patient who is a psychiatric patient. And let me remind you, this case which started is not by any surgery or orthopedics or gynecology or pediatric case. It started from a psychiatric case. So Bolam's is a person who is a recurrent depressive disorder patient, and he goes to Friern hospital for treatment of recurrent depression. Basically, he's suffering from depression. It is during 1952-53, during that period. See, this case was decided on 1957. So that is in UK. So this person, being a voluntary patient, he goes to Friern hospital. He's been diagnosed as depression. He's been advised electroconvulsive therapy, what we call it as a shock treatment or a current treatment. So he's been advised and he agrees for electroconvulsive therapy. So during that period, there are two types of electroconvulsive therapy. One is you are giving electroconvulsive therapy without any kind of anesthesia or muscle relaxant or restraining the patient. That is called as unmodified ECT. The next one comes is modified ECT, modified electroconvulsive therapy. That is basically will give anesthesia, muscle relaxant, and you are going to restrain the patient. So please do remember, this is during 1950, 52, 53. So that's the time. So here the Friern hospital goes ahead with giving unmodified ECT. They do not offer him any anesthesia, muscle relaxant, and also any restraint. In the first electroconvulsive therapy session, nothing happens. Invariably, they are given in the dosage like 7 to 10 electroconvulsive therapy. So each session means one set of electroconvulsive therapy is given. One set means one ECT, one session. Basically, it is given today, and one day there will be a break, and again day after tomorrow. On alternative days, it will be given over a period of 15 to 16 days. There will be 6 to 7 electroconvulsive therapies will be given. That is usually considered as an adequate therapy for ECT, for depression. So here he receives first session of ECT, nothing happens. Second, nothing. Third, he improves in depression, but because he has not received anesthesia or muscle relaxant, or there is no restraint, he goes for a violent muscle contraction and he develops acetabular fracture. That is basically hip fracture he develops during the electroconvulsive therapy. By this time he has improved with depression. Now he is very angry with the hospital. He goes to court. Though they treated my depression, but unfortunately they had given me fracture. So the hospital is negligent. This is he goes and argues in the court of law. So now the court in UK, they looked into the matter and found there was no any case of medical malpractice or medical negligence case who have asked for compensation. There was no such cases. So at that time, the judge McNair is the person who who was the chair at that time for the decision. So what he does is he will decide what he doesn't know what to do. So what he thinks of calling experts. So he will call experts. So when the experts are called, so around 50 to 60% of the experts said that we will not give anything because it is around 1950-55 time, and anesthesia, muscle relaxant, restraining, and warning about the fracture is one that is not to be giving because there are a lot of side effects with giving anesthesia or muscle relaxant at that 1952. The other group said, no, there will be these kinds of problem. We have to give anesthesia, muscle relaxant. So 50% on either side. So again, the judge was slightly taken aback because even the expert opinion is not saying whether the doctor has erred or not, or there was a medical negligence. So at this point of time in 1957, Judge McNair comes up with a landmark judgment. Based upon this decision, the whole medical negligence case across the world is decided. So let me remind you, the ECT with anesthesia and another one is without anesthesia. So there are two types of practices were there at that time, 1955-56, during that time. So Judge McNair gives this decision. He says the doctors at Friern Hospital are not at all negligent. The reason being is the doctors in that hospital were able to follow one of the standard practice which was prevalent at that time. There were two practices, ECT with anesthesia and muscle relaxant, that is called as modified ECT, unmodified ECT. Without any anesthesia, you are going for ECT. So since the doctors were able to follow one of the practice which was prevalent at that time, the doctors are not negligent. And also, if a doctor reaches the standard of responsible medical opinion, that is the medical body of opinion gives that this is what the prevalent practice is, he is not negligent. See, look how beautifully the judge decides about this. It is a, though we can call it as a common sense or anything, during that any guidance, the Judge McNair gives this landmark judgment. And I will repeat again, a doctor is not guilty of negligence if he has acted in accordance with the practice accepted as proper by a responsible body of medical men skilled in that particular art. So the doctors from the hospital followed one of the practice which was prevalent at that time. The next question asked maybe whether these Bolam test is followed in India. Of course, if you look into Jacob Matthew case, which is again a landmark case in criminal negligence, Dr. Suresh Gupta versus NCT Delhi, again another landmark judgment. I'll be discussing these issues. In 2004 and 2005, they have been taken. The Bolam test has been accepted. So there is no way we can say that Bolam test is not accepted in India. It is in fact accepted across the world. Further, if the doctor, the Bolam test in that it also says failure to use such care or a precaution, a reasonable, prudent, careful person would use under similar circumstances. That means if a doctor working in a district hospital, okay, a doctor working in a district hospital has to follow certain precautions, whether he will follow that, a reasonable, careful, prudent doctor of a district hospital, if he is able to follow that, is not negligent. That's what the this statement means. And also, this Bolam test also had a fair amount of what we call it as publicity. At the same time, it also has been criticized. See, Bolam test, to know whether the doctor is erred or not, you have to call an expert. The experts are none other than these colleagues. So it is also called as a peer review test. For medical professionals, which is used to assess whether the person is negligent or not, it is called upon by his own fellow colleagues. So it is also called as peer review test. At the same time, a doctor must demonstrate that he or she acted in a manner in which a responsible body of medical professionals who work in the same field would seem that it was reasonably appropriate. But however, though the Bolam test is well accepted, but civil society, many legal luminaries feel that it is basically a peer review test which may not be acceptable. This is how the Bolam test has been put up for scrutiny. Summarizing the Bolam test, a failure to match up to the required standard of care. So this is very essential, and all the doctors in the fraternity need to know that they have to follow a reasonable degree of standard of care. A peer review test will be applied to assess the standard of care. That is how the Bolam's test has been discussed across the world, and it is accepted even in India. To conclude, the medical professionals are entitled to get protection so long as they perform their duties with reasonable skill and competence and in the interest of the patient. So the interest and welfare of the patients have to be paramount for medical professionals. Thank you very much.